I am Kimball Parker. I'm the CEO of SixFifty. And for those of you that are hearing about SixFifty for the first time, we work with the law firm Wilson Sonsini to automate the legal documents that a lawyer would typically write for you. So lawyers write documents all day. That's what they do. That's what I did when I was a lawyer. And those documents need to say the right things. And if not, there are serious consequences. And that's especially the case with employment agreements. So the majority of lawsuits against companies are employment related. And a failure to follow the law in your employment agreements can be devastating. So what we've done at SixFifty is work with Wilson Sonsini and actually one other firm, just to double check, to teach a computer to write offer letters, employee contracts, and all the other hiring paperwork you need. And we built the tool so that those documents meet the law for every state, for all 50 states. So with COVID now, companies are having to hire people across the nation. And this tool now provides the paperwork for them to do that. So if they want to hire someone in West Virginia or in Alabama or North Dakota, we've looked at the laws in every single state, and we can help a company hire anywhere across our nation. So our products are like TurboTax in that you answer questions and it creates a document for you, but with the best lawyers in the nation behind it. So okay, so that's about SixFifty. Today we're going to talk about some of the important considerations in those employment agreements. And we have an all-star lineup for you. First, we have Adrian Jack. Adrian graduated near the top of her class from one of the best law schools in the nation, Northwestern. And she then worked at some big law firms, some of the biggest, most important law firms in the nation. And we are able to snag her away. So Adrian, a big portion of her practice was employment law, and she's poured that expertise into this new product. Second, we have Adam Wright. Adam, just like Adrian, graduated near the top of his class from one of the best law schools in the nation, the University of Michigan, go Blue. And Adam clerked for, I think, two years for federal judges, and then worked for some of the best law firms in the nation. And we were able to pull Adam away. Adam and I actually worked in the same law firm. And so when we started to do SixFifty, I pleaded with Adam to join us, and finally he did. So you're not going to hear from two smarter people in your entire life than Adam and Adrian. Two things: if you want to learn more about our 50 state employment agreements, you can visit www.sixfifty.com/employment agreements. So sixfifty.com/employment agreements. There you can sign up for a demo. You can learn more about the tool, so on and so forth. Second, if you have a question or comments, put them in the Q&A. That's a little button on the bottom of your Zoom pane. And it's not a big deal if you put them into the chat, but we can answer them more easily, and we can aggregate them and send out a Q&A after if there are a lot of questions, if they're in the Q&A part of Zoom. So, okay. So again, there are a lot of complicated things about employment agreements, non-competes, non-solicitations, arbitration, so on and so forth. And Adam and Adrian they're going to dive in here. So without any further ado, the dynamic duo of employment law, Adam Wright and Adrian Jack. Take it away.
Thanks, Kimball. Thanks for the nice introduction. Well, we're really excited to be here today talking about the legal agreements that companies need to throughout the employment life cycle, and talk about the considerations needed there, and also SixFifty's tool in helping companies draft those legal agreements customized to the states wherever you have employees. So let's briefly take a look at today's agenda, see what we'll be talking about. So I'm going to dive in and start talking about offer letters, what companies need to be thinking about when drafting offer letters. Then we'll move on to talk about employment contracts. There are a ton of considerations there that employers need to be cognizant of, and risks for getting it wrong there. So we'll talk through some of those considerations. Then I'll turn the time over to Adrian to talk about separation agreements, independent contractor agreements, and non-disclosure agreements. And then at the end, we're going to turn it back over to Kimball, who will give everyone a demo of 650's tool to help companies draft and automate these agreements. And then finally, we'll leave a few minutes at the end for question and answers. But as Kimball said, if you have questions throughout, please feel free to put those into the Q&A function here in Zoom, and we'll do our best to answer those throughout the webinar. Okay, let's jump in and talk about offer letters. So offer letters are typically going to be your first formal legal document that you have with a potential hire. And so it's something that you really want to get right. You want to make sure you're clearly communicating the terms of the offer and the expectations of employment. And so what are offer letters going to include? What should they include? So I think one thing, especially now in this new employment environment, that companies should be clearly communicating in an offer letter is whether the position is in office, remote, or hybrid. So obviously this is something that is at the top of mind for employees and employers right now, as the pandemic has shifted the way we work. It's something that needs to be clearly communicated to an employee. So if they're expected to be in the office full time, that needs to be clearly stated, state which office they're being hired in, obviously. If it's remote, where the employee's not going to have a dedicated office space, that needs to be stated. Or if it's a combination of the both, that also needs to be clearly communicated. An offer letter should also include whether the position is full-time or part-time, the position or title for which the employee is being hired, whether the position is salaried or hourly, what that salary is or what the hourly wage is, whether the employee is eligible for a starting or annual bonus. And starting bonuses are something that we're seeing a lot these days, especially if you're in an industry with a tight labor market where it may be difficult to find workers. We're seeing companies using that a lot. So an offer letter is a great place to communicate a starting bonus. If the employee is going to be paid on a commission basis, that should be clearly stated. Oftentimes, and it's a best practice, in fact, for companies to also have a written commission agreement that communicates how commissioned employees are paid. And so that should be communicated in the offer letter as well. Employers should state whether the employee is exempt or non-exempt under the Fair Labor Standards Act, and that just means whether the employee is going to be covered by overtime and minimum wage laws. Offer letter is a great place to put in benefits that the employee may be entitled to. And then obviously you're going to want to include the start date for the position. So let's move on and talk about what risks there are for companies when it comes to offer letters. So offer letters are not legally required. There's no state that mandates that employers provide an offer letter, but using an offer letter is a best practice because there are potential legal consequences for not using them. So even though they're not required, they really can go a long way in helping companies comply with the law. And I think it's important to note here that this dynamic might change, right? This is an area of the law that we have seen change, where we may, anticipate states passing laws that are going to require employers to provide certain disclosures at the time of offer, as opposed to disclosures at the actual time of hire. So for instance, in Connecticut recently passed a law which requires employers to disclose the wage range for the position that you're hiring the employee for at the time of offer. And so the tool which Kimball is going to demo for you, our offer letter tool, if you tell us that your employee is located in Connecticut, we're going to include a question about what's the wage range for this position, to make sure that your offer letter is complying with that Connecticut law, for example. Offer letters should also include a clear statement of at-will employment. So at-will employment, you probably know, just means that the employee or the employer can terminate employment at any time for any reason, so long as that reason is lawful. And failing to include a statement of at-will employment, it can risk the at-will status of the employee. And so what does that mean? That means that instead of being able to terminate the employee for any reason that's lawful, you now can only terminate the employee for cause. And so we'll talk about at-will employment provisions in employment agreements as well. But it should also be very clear in the offer letter that the position is at-will employment, unless you're in Montana, which is the only state that does not follow at-will employment. Your offer letter should also include any notice requirement for restrictive covenants and take that notice period into account when setting a start date for the position. So what are we talking about when we say restrictive covenants? Those are things like non-solicitation provisions or non-compete provisions. And we'll talk a little bit more in detail about non-compete provisions, but we are seeing states rein in the use of non-competes across the country, across the political spectrum. And so what are those states doing with those laws? Well, one thing they're often doing is requiring employers to provide advance notice that a non-compete is going to be part of a requirement for employment. So depending on the states, it may be that the employer has to give the employee 7 to 14 days to review the terms of that non-compete, talk with an attorney if they want, and then decide whether or not they want to sign the agreement. So obviously, when you're thinking about what the start date is, for example, if you're in a state that has a 14-day review period, if you, for example, make an offer on March 1st, you can't put the start date as March 13th, right? Because that's not going to comply with the 14-day notice period. So if you're in one of those states that has a notice or review period that's required, if you use our tool, it's going to automatically include that, right? So if you're in, for example, Illinois, which has a 14-day notice period, a review period, we're going to provide you that information and make sure that if you're using a non-compete, that your offer letter is giving that required notice period. DC is has an interesting new non-compete law that's going into effect early 2022, I think in the spring of 2022. So their law bans non-competes, but it has this interesting notice provision that requires employers, to affirmatively tell employees that non-competes are unlawful in DC. And if you don't do that, you're risking a $350 to $1,000 fine for every violation. So every employee, for every employee you don't provide that notice to, you're potentially subject to that fine. And so if you're in DC and you use our offer letter tool, we will include that required notice in the offer letter for you. It's important to note that these notice requirements are becoming more common as states are rapidly passing laws to rein in non-compete. So it's something that you can expect to see more of and something that you really need to be on top of in every state that you have employees. All right, so let's move on and talk about employment contracts. So your employee has accepted the offer letter. Now you're moving on to signing an employment contract. And I should say one other thing about offer letters, which is that the offer letter should reference the employment contract and tell the employee that they're going to be required to sign the employment contract, and the offer letter should attach the employment contract along with it so the employee can review and sign that. So the employment contract is really the foundation of your company's legal relationship with an employee. There are a ton of considerations here when it comes to the provision you do or don't want to include. And so let's talk about some of the provisions that an employment contract might contain. And actually, first, before you do that, just one note on the importance of employment contracts, right? It's really key to have a good contract in place. And why is that? Because if you don't, you're potentially putting the company's confidential information and trade secrets at risk. You're putting the company at an increased risk of litigation. And if, God forbid, there is litigation, you're exposing the company potentially to increased litigation costs. And having a bad employment contract really is almost as bad as not having one at all. Because companies need to make sure that they're really complying with the law. The specific provision for every provision included in that contract, you're complying with the law of the state that governs that provision. And if it does, which again is going to expose the company to the risks I just mentioned. So employment contracts can be used for new hires or current employees. If I think most typically it would be used for new hires, but maybe there's a company that is a small company. It started off really informally, so it hired people, but they didn't have written employment contracts. And the company's deciding, I really want to button up our employment practice here and have everything written. That might be a circumstance where a company wants to use an employment contract for a current employee. Okay, so now, sorry, moving on to the specific provisions here. So again, at-will employment provision is really important. Let's go back, sorry, to the previous slide. So an at-will employment provision is really important, which we've already talked about. That should be included in your offer letter and your employment contract for the reasons we've already talked about. A confidentiality and non-disclosure provision is really important to have. And so this is a provision that's protecting the company's intellectual property and trade secrets. And this is an area of the law that's actually changing pretty quickly too. And states really need to be, or companies really need to be aware of the laws, the governing confidentiality and non-disclosure provisions in the states where the use of NDAs to ensure that they're not being used to prohibit employees from disclosing factual information about unlawful employment practices in the workplace. And most notably, that would be things like sexual harassment. So there have been a lot of state laws recently that that prohibit employers from using NDAs in that way. And so a lot of thought needs to go into the confidentiality and non-disclosure provision you're using based on the state where your employee is. Employment contracts can include invention assignment agreements, and those are just provisions that that assign any intellectual property that the employee creates during employment and during work hours using the company's resources. The employee is going to assign the right and ownership to that intellectual property to the company. So those are really important provisions to have if you have employees that are creating any kind of intellectual property, like any material that can be copyrighted, trademarked, or any inventions that would be patented. Okay, talking about non-solicitation, that is really state specific. States have specific limitations on how non-solicitation provisions can be used. And those are just provisions that prohibit an employee from soliciting the company's customers, employees, or third parties after employment. Non-competition provisions, we're going to talk a little bit about in more detail, so I won't go into that deeply right now. And so, yeah, we'll talk about that in just a second. Next, arbitration provisions. So an arbitration provision, you may know, is a waiver of both the company and the employee's rights to pursue any dispute publicly in court. So instead of filing a lawsuit in court, both the company and the employer agreeing to resolve the dispute in a private forum, which is known as arbitration. Employers typically like to have arbitration provisions because arbitration can be a lot cheaper and quicker than traditional litigation in court. This is also a very dynamic area of the law that's moving a lot right now. There are a lot of states that are passing laws that are attempting to ban mandatory arbitration provisions for employment disputes. So far, most of these laws have run into trouble because they conflict with a really broad federal law on arbitration that takes precedence and is really friendly to arbitration. But again, that might be changing. So there's a recent California law that was passed that bans mandatory arbitration for pretty much any employment dispute. And that has actually found success in the courts recently. The Ninth Circuit has upheld that law as not conflicting with the federal law I was talking about. And so that law is actually in effect right now, pending some more appeals. But again, that just highlights that companies really need to be aware of the laws in the states where they operate, which are purporting to ban mandatory arbitration for employment claims. And then finally, jury trial waivers. These are provisions in which if a dispute under the employment agreement does end up in court, and if it goes to trial, instead of being tried in front of a jury, provisions, because I think the common thought is that an employer is going to get, and probably depending on the jurisdiction you're in, but employer may get a more fair shake in front of a judge rather than a jury. And so at least that's the common thinking with a lot of companies. And so that's why companies like to include those provisions. So obviously each of these provisions have their own considerations that companies need to think through, but probably the most complicated and risky one are non-compete provisions. So let's briefly talk about that. So I mentioned this is an area of the law changing fast. We really went into this in more depth in a webinar last week. So if you're interested in more detailed information here, you can check out in 25 different states have been introduced attempting to rein in the use of non-competes. There was an executive order from President Biden asking the FTC to issue a rule curtailing the use of non-competes. We don't know what that'll look like yet. That may take some time to be issued, so stay tuned there. And then in terms of how states deal with non-competes, there's really 3 buckets of states here. So the first group of states, which is fairly limited, completely bans non-competes for employees. So that would be California, Oklahoma, North Dakota, and then probably soon DC. Like I said, there's a new law that is likely will be going into effect early next year. There are a minority of states, which is actually, it's a group of states that is growing, that have passed laws that restrict the use of non-competes by using things like income thresholds. So if an employee doesn't make X amount of dollars, you can't include a non-compete. And also those laws often use notice requirements, which we've already talked about. Most states right now don't have specific statutes that limit the use of non-competes. It's really up to the courts to limit how non-competes are used. But the tool, again, that Kimball's going to demo for you all helps company comply with this fast changing area of the law in all 50 states plus DC. Okay, moving on to the next slide. Some of these requirements that are state specific. So in addition to legal requirements that non-compete agreements be reasonable in their time, geographic, and activity restrictions, there are some specific restrictions in states that I'll just highlight briefly here. So we've already talked about the notice period, and those are in states like Illinois, New Hampshire, Massachusetts, Maine, Minnesota, Oregon, and Washington. Some of those states also require companies to affirmatively encourage employees to consult an attorney about the use of non-competes. So Illinois and Massachusetts require extra consideration for non-compete to be enforceable. And consideration, when we say that, we're just referring to the legal benefit that's exchanged. So in this context, we're talking about what the company gives an employee in exchange for a promise not to compete for a certain time after employment. So historically, just offering an employee a job is enough consideration to support a non-compete, but that's changing again. So Illinois and Massachusetts require companies to pay something more. So an extra payment, or give the employer a raise, or a bonus, or something like that to support the non-compete. We talked about income thresholds. So a handful of states use income thresholds, saying that if an employee doesn't make, in Washington and Oregon, for example, it's about $100,000. If you use a non-compete for someone that makes less than that, then it's going to be unlawful. In Nevada, they've taken an interesting approach and just banned non-competes for hourly employees. So as you can tell, this is really state specific and changing quickly when it comes to non-competes. So companies really need to be on top of that law, and the risk of not being on top of it and using an unlawful non-compete is that, one, your non-compete's not going to be enforceable, and then two, you're potentially subjecting the company to fines or civil penalties depending on the state. And so we'll talk a little bit about that now. So moving on to the next slide. And like I said, in some states, employers can face civil penalties for including unlawful non-competes in employment agreements. Washington is an example of one of those states. In Washington, if you use a non-compete for an employee that makes less than $100,000 a year, you don't give
Adam,
the adequate notice,
you're cutting up a little bit there, Adam.
It's not going to be enforceable, and you may be subject to a violation. So this is a recent headline where we're abusing non-competes, which was, yep. Oh, sorry. Can you hear me now?
Yep, you're okay now.
Okay. Sorry, I don't know where that cut out, but this is a recent headline from Washington. I'm sorry if I'm repeating myself and you heard this, but where the Attorney General investigated a company for abusing non-competes, which resulted in a fine of $110,000. So employment contracts have a lot of moving pieces. The law is changing quickly in several areas of employment law. So there are a lot of things employers really need to be thinking about when entering contracts with employees. So I'm going to turn the time over to Adrian now to jump into talking about separation agreements.
Thank you, Adam. So if the employment relationship has reached an end for a variety of reasons, a separation agreement or a separation acknowledgement can be used between a company and a departing employee. These documents can memorialize that the employee is departing the company and communicate the implications of that departure to both the company and the departing employee. This can be done through either a separation agreement or a separation acknowledgement. So a separation agreement is typically a contract signed by both the employee and the company that has more robust separation provisions, such as severance pay and a waiver and release agreement, compared to a separation acknowledgement is typically a shorter document signed by only the company that memorializes that the employee is terminating employment, but does not have some of the same provisions such as severance pay or a waiver and release agreement. Our tool offers companies the option to use either of these tools, either a more robust separation agreement or a shorter separation acknowledgement. To determine which of these documents is most appropriate, the company should understand the reason the employee is leaving employment. Understanding and documenting this reason can help a company correctly handle the termination. There could be numerous reasons for an employee's termination. The employee could be leaving to work for a different company. The employee may have engaged in misconduct, such as violating a company policy or procedure. The employee may have a performance issue that has not been corrected, or the position may no longer be needed. The company is conducting layoffs or a variety of other reasons. But documenting the reason for termination can be helpful to avoid potential lawsuits. We all know that companies can't discriminate against employees based on protected characteristics such as race, religion, sex, sexual orientation, national origin, and certain other factors. So if a company documents the reason for termination in a separation agreement or separation acknowledgement, such as the employee has performance issues that cannot be remedied even despite having been giving notice for these, that helps the company show that the termination was not due to discrimination. Also, documenting the reason for separation can clarify the employee's eligibility for certain benefits, such as unemployment insurance. Typically, employees are not eligible for unemployment insurance if they voluntarily end their employment with the company, except in limited circumstances. But they are eligible if they are terminated for factors beyond their control, such as due to layoffs, downsizing, the lack of available work, etc. So having a written record in a separation agreement or separation acknowledgement can help the employee and the company know what benefits the departing employee may be eligible for. Similarly, companies should track and review why employees are leaving the company, as it is helpful to understand this information and is a great place to document it in separation agreements. Understanding why employees are leaving the company can help the company improve its retention and culture. So in deciding between separation agreements and separation acknowledgements, one of the first questions besides why is the employee terminating is, will the employee be asked to sign a waiver and release of claims? A waiver and release of claims is an agreement between the company and a departing employee where the employee agrees not to raise certain claims against the company in the future. A waiver and release is typically or must always be accompanied by consideration. And this consideration most typically takes the form of severance pay, which I will talk about more in detail shortly. A waiver and release of claims can benefit a company by minimizing the threat of litigation, arbitration, or other formal proceedings against a company. One study by an insurance journal found that small and medium-sized businesses in the United States have about almost a 20% chance of facing employment law claims. And this rate is higher in certain states, such as Washington, D.C., California, Alabama, and New Mexico. Employment proceedings against a company can be expensive due to attorney's fees, litigation fees, damages, or potential settlement amounts. They also damage the company's reputation and goodwill, and they disrupt the company's operations as they're going on. So a waiver and release of claims drastically reduces the likelihood of facing employment law claims, such as wrongful termination, or compensation claims, such as failure to pay overtime, or employment discrimination claims, or workplace injury claims. However, to be truly beneficial, the waiver and release of claims must be carefully drafted. Certain rights cannot be waived by employees, and other rights can only be waived with the appropriate language, limitations, or procedure. Federal, state, and local law prohibit certain kinds of waivers of rights, so these rights have to be carefully carved out. Additionally, certain procedures must be followed when presenting an employee with a waiver and release of claims, depending on the state where the employee is located or the types of claims that are being waived. Some federal and state laws require companies advise the departing employee that the employee has the right and is advised to consult with an attorney to consider the waiver and release of claims, and also allow them a certain time period to review that waiver and release of claims. For example, if employees are asked to waive age discrimination claims under the Age Discrimination in Employment Act, the ADEA, companies must provide employees in writing that they are advised to consult with an attorney before signing the waiver and release agreement. Also for ADEA claims, companies must provide employees 21 days to consider whether to sign the waiver and release agreement. Some types of claims and states also require that a company allow an employee the right to rescind or revoke a waiver even after they've already signed it. For example, a new law in Illinois requires that companies allow employees to revoke a waiver and release of claims within 7 days of signing it. And this could apply to any type of claim that the employment claim that the employee waived. Similarly, Minnesota has a requirement as well. So if this notice period and this revocation period is not provided to employees, then the entire waiver and release of claims could be invalid, which offers no benefit and protection to the company. So while a waiver and release of claims can be a valuable resource to companies, companies need to be aware that there are limitations and procedural requirements that must be followed to ensure that the waiver and release of claims is valid and enforceable. Our tool offers companies customizable waivers and releases based on what states the employers are located, as well as other factors to ensure that companies are getting a valid and enforceable waiver and release of claims. So if a company decides to use a waiver and release of claims, the company will need to provide severance pay or other considerations for the employee to sign such a waiver. Severance pay is most often used because the company is asking the employee to sign a waiver and release of claims, but a company could also offer severance pay because it is required to do so under an employment agreement, a severance policy, or a collective bargaining agreement. The amount of severance pay can be determined on a company's severance pay plan or policy, or the amount can be determined on a case-by-case basis at the company. And this really depends on how often the company is offering severance, the company's past policies and procedures, and other factors. So if the company has a severance plan or policy, this could set forth a standardized way to determine the amount of severance, such as through a formula, such as 1 week of severance pay is provided to employees for each week of service provided to the company. However, in some cases, a company might want the flexibility to either to leave the policy or to work outside of the policy based on how strongly the company values an employee signing a waiver and release agreement. If a company is concerned that an employee has a potential claim against the company would be willing to offer more severance pay to get the employee to sign a waiver and release agreement. The severance payment provided to employees can be as a one-time payment, or it can be provided over time. And that should be documented in the separation agreement, which our tool allows companies to indicate. A company, in addition, as part of the severance pay package, a company can offer employees subsidized COBRA premiums as part of their separation package. COBRA requires companies with 20 or more employees to offer healthcare coverage to employees who otherwise provide that benefit after individuals terminate employment, if it's due to a qualifying event. So companies must provide this COBRA coverage to departing employees for 18 months after termination. Employees are typically responsible to pay the full cost of the insurance premium, and federal law even allows employers to charge 102% of the insurance premium to cover the company's administrative fees. But companies may want to offer subsidized, either fully or partially subsidized COBRA premiums as part of a severance pay plan. Also, as part of a separation agreement, companies need to ensure departing employees are bound by restrictive covenants. As Adam mentioned, arbitration provisions, confidentiality provisions, and restrictive covenants such as non-compete and non-solicitation provisions offer great benefits to a company and protect a company's confidential information. If a departing employee is already subject to some of these provisions, such as in an employment agreement or other agreement, the separation agreement should refer back to that prior agreement and remind the employee that they are subject to those provisions after termination. But even if the employee isn't already subject to those provisions in an employment agreement or other agreement, the company can still include those in a separation agreement, and that still provides great benefit to a company. And our tool allows companies to either refer to prior agreements where an employee entered into these provisions or provide them for the first time. So in connection with an employee's termination, companies should be prepared to provide the required federal and state notices to departing employees. For example, federal law requires that companies provide departing employees notice of their eligibility for COBRA continuation, and this notice has to contain certain information. Similarly, there are many state-specific notices that companies must provide to departing employees within a certain time period after termination. And this can get complicated really quickly if companies have employees in multiple states. Keeping track of which notices and forms must be provided to each departing employee. So some states require companies complete a specific form in connection with an employee's termination, and that's often can be a state-provided form on a state website. And this form might need to be filed with a state agency or provided to the departing employee on that specific form. So it can be helpful to attach these required forms with a separation agreement or acknowledgement. So the company is documenting that they complied with the required notice requirements, and it gives the employees the information they need in one place. Failure to meet these required notice requirements can subject a company to fines that can be pretty significant, such as in New York, companies can be subject to a $5,000 fine per employee for failing to provide the required termination notice. So our tool helps companies comply with all of these different notice requirements by referring them or linking them to what needs to be provided to departing employees and offering the company the option to attach that to a separation agreement to ensure it's effectively provided to the employee. Finally, one of the last steps in the separation agreement is to get the employee's signature in connection with the termination. So if a company is asking an employee to sign a separation agreement that contains a waiver and release of claims, obviously this would need to be signed by the departing employee. However, even if the company is only providing a short acknowledgement to the departing employee, noting that they are terminated and other certain factors, it might also be helpful to receive an employee's signature in connection with that termination acknowledgement. That way the company can document they provided the required notices and sent this information to employees. Separation agreements are typically the last document in the employment life cycle, but it's not the last one that we're going to talk about. Many companies utilize independent contractor agreements to help, many companies utilize independent contractors to perform services for the company. So we'll turn to those next. Independent contractor agreement is typically an agreement signed by an independent contractor and the company by the contractor who's performing services for the company. The distinction between an employee and an independent contractor is one of the most complicated areas of employment law. This determination has significant legal and tax consequences and is the center of many cases and legislative focus. For example, in California, the distinction between an independent contractor and employee is a very hot issue. This California Supreme Court implemented an ABC test in 2018 to determine if a person is an independent contractor, and that test was then codified in 2020. In November of 2020, voters then approved an exception to this rule, indicating that certain gig workers, such as ride hailing and food delivery service providers, are considered independent contractors. So this area is very thorny and very complicated, and it is based on federal law as well as state law. So ensuring that a person truly is an independent contractor is a very important first step. But once this independent contractor status is confirmed, a company can then prepare an independent contractor agreement. An independent contractor agreement should include several provisions, such as a description of the services that the contractor will be providing to the company. This will help ensure that the company and the contractor understand the scope of the services and are on the same page. This can also include a description of any project milestones, deliverables, or estimated completion dates that are expected by the independent contractor. This agreement should also describe the expectations of the contractor. This includes whether the contractor is required to perform a certain number of hours of services to the company. Also, the agreement can outline the expectations with regard to communication. So if there's a specific person at the company that will oversee the contractor or communicate with the contractor, that can be included in the contractor agreement. Also, the contractor agreement should indicate how the parties will communicate if the scope of the project or the terms of the project need to be changed, including if the contractor has difficulties in completing the services or their expected delays. So if the company would like a certain notice period from the contractor with regards to delays or changes in the agreement, that should be included in this agreement so the contractor is clearly aware of them. Also, the agreement should define the term or length of the relationship. The length of the contractor relationship can either be a specific time period in weeks, months, or years, or it can be based on the completion of a specific project. The contractor agreement should also address compensation. This includes the contractor's rate of pay and the payment terms. So the rate of pay can be hourly, weekly, a monthly rate, or a rate based on completion of the entire project. Also, there are also the same amount of flexibility with when a contractor will be paid, whether that's weekly, twice a month, monthly, or based on the achievement of certain milestones. The agreement should indicate if the contractor is required to follow certain requirements to get payment, such as providing an invoice to the company, providing an update or certification that certain portions of the project are completed. The independent contractor agreement should also establish the terms of what it means to be an independent contractor. And this is really helpful to bolster the company's position that this person truly is an independent contractor and not an employee of the company. So the most basic of these is a statement in the agreement that this person is an independent contractor, not an employee of the company. However, there are other provisions that can be included to further support this position, such as a statement that the services provided by the contractor are not part of the company's usual course of business. Also, a statement that the contractor has the right to control the services, such as the means and the manner and the method how the services are performed, as well as the fact that the contractor will provide all of the tools and equipment necessary to perform the services, and that the contractor has a right to hire assistants or subcontractors. The agreement can also indicate that the contractor is responsible for federal and state withholding obligations, unemployment contributions, and obtaining workers' compensation insurance. Finally, the agreement can indicate that the contractor is not eligible for any benefits or insurance. Our tool includes an independent contractor agreement that has all of these positions and other best practice provisions drafted by some of the best employment lawyers in the nation to ensure that a company has a really robust independent contractor agreement. Finally, some of the other provisions that Adam talked about that could be included in both an employment and an independent contractor agreement include non-disclosure provisions. Since independent contractors similarly have access to company confidential information, they should be bound by provisions to keep this information confidential, as well as assignment of intellectual property provisions and indemnification provisions. These can all protect the company in the same way that it protects the company with respect to employees, as Adam discussed. So independent contractor agreements are greatly beneficial. And there's one other kind of agreement that we'd like to talk about that can be used in unique circumstances. So both employment agreements and separation agreements and independent contractor agreements have non-disclosure provisions. However, we also offer a standalone non-disclosure agreement. This can be helpful if the company would like to use with certain individuals that might not enter into those other types of agreements. For example, one situation that occurs most often is that a company is interested in hiring an employee or independent contractor, but is not sure whether to do so and needs to discuss confidential information with that person before deciding whether to extend an offer of employment. And so using a non-disclosure agreement can be helpful to ensure that the company can have those conversations it needs to make a decision about employment, but also has protection that the information will be kept confidential. So these are all the different documents that are offered in our new tool set that Kimball will demo for you. So I'm excited to turn the time over to him to show you this tool that we worked hard on.
Adrian, Adam, thank you very much. Some real great employment agreement information. So I'm going to take the rest of the time up today and show you the tool on a really basic level. So I'm going to do two things. First, I'm going to show you a little video about how the tool works generally, and then I'm going to show you how it works specifically with regard to employment agreements. So I'm going to share my screen now. Here we go. We have a how it works video. And so I'm going to show you this. This will give you just a rough idea about how our platform works as far as answering questions, creating documents, getting updates, etc.
Hi, I'm Emily Binch, and I'm a Customer Success Manager at SixFifty. Using our platform to create customized legal documents is easy, simple, and intuitive. Let me show you how. When you log in, you'll see the categories of documents you can create on the left. This will vary depending on what products you purchase from SixFifty. Choose the category of documents you need, and then click New Document. A list of available documents will then appear with a brief description of each. Choose the specific document you want by clicking Create. This will bring you to a list of questions about your business. You can answer them in any order you like. Our system will take your answers and create a customized legal document just like a lawyer would. When you finish the questions, you'll see the documents you've created in a list. Wait for 60 seconds as our system customizes your documents and then refresh your browser. You'll then see a download button appear, which means your documents are ready. We gave you the legal document in Microsoft Word so you can edit the contents as you like afterward. The law can change frequently, and every time it does, you need to update your legal documents. That used to mean lots of time, money, and stress, but not with SixFifty. We alert you by email and in-app messages whenever the law changes in a way that impacts your documents. All you need to do is regenerate it in the system. It's the easiest way to generate top-tier legal documents and keep them up to date.
Okay, so that is the voice of Emily Binch, one of our customer success managers. And so if you end up buying the tool, there's a pretty good chance that you'll run through Emily. She's fantastic, one of our best employees. So here's what it looks like specifically with employment agreements. So here you go. Here's the list on the left. You see employment agreements here. You click on that. You can see the different employment agreements here. We have an employee contract, an offer letter, independent contractor agreement. We have an NDA and a separation agreement, all the documents that we talked about today. If you go into the, let's say, employee contract, then, well, actually, so let's go to all, and you can click new document, and you can kind of see all the different documents that are offered here. So actually, let's just go to employee contract and click new document. Now, this will take you into the questions that you need to answer for that document. And so you can answer these questions in any order you want. The following questions will help you decide whether to include a non-compete or non-solicitation provision. I understand. Depending on how you answer some questions, then it'll add more questions. Do you want to include an invention assignment agreement? Yes, no. And then when you're done, then you can download the document here. So I created one earlier this morning. Okay. And then here is a perfect, 99th percentile lawyer document, created employee contract. So this contains all the provisions you want. They say the right things for the state that you're worried about. I believe I picked Utah in this one, and then all of the exhibits you need in addition to that contract. So everything that they need to sign and have at their disposal under federal and state law for the states you select. And so you can run the same process for offer letters, independent contractor agreements, NDAs, and separation agreements. And each document will take you, let's say, 5 to 10 minutes to do. The employee contract can take a little longer depending on how deep you want to go into creating non-competes and non-solicitations. But pretty quick process. So instead of contacting your attorney, having several calls with them, getting it 2 weeks later, paying by the hour, you can just come in here, create the document, send it out. And have it all ready. So we tried to make this as easy as an experience as you can have. You can, once you sign up for our service, you can create as many employment agreements as you want. You could do 1,000 offer letters with this. We have no limitation on that. You can have as many people join tool as you want. So you could put the leaders of each organization onto the tool where they're creating their own employment agreements. And so very, very easy that way. And then for those who want to use the tool, we can onboard you in a few days from when you buy it. So pretty easy onboarding process too. The pricing starts at about $200 per month, depending on your employee count. And so it scales up for bigger companies, but starts for small companies at about $2,400 a year, or about $200 per month. So that's the tool. It looks like we have a question. Can we pre-configure the default selections to create a template for particular roles, or do all the questions need to be answered at each time? That's a really good question. So you may want different agreements for different roles, and yeah, we can help you with that. So we can help you create different iterations of this within the tool. Like, so we can help guide you through, like, okay, so for, let's say you're a retail store, for your on the floor retail employees, you'll want to follow this pattern, and for your executives, you'll want to follow another one, and we can create kind of two different instances for that for you. So yeah, we can get pretty detailed there. Let's just looking to see if there are any other links. What is considered a small company? That's a good question. We're thinking about maybe 25 employees and under is considered a small company for us. And then kind of goes up from there. But again, when you talk with one of our account executives, they can walk you through the pricing. It's pretty simple. Another question: are there e-signature integrations for SixFifty? This is a really great question. We are actually working on that right now, so that you can, we're working on a way so that you can send the employment agreements out from our system and track when they're signed and everything without having to leave our system. Right now, we provide you with a Word copy that then you can put into DocuSign, but we're working with kind of tighter, with tighter e-signature integrations. This is actually one of the fun part of kind of working with SixFifty is we're taking user feedback and we're making the product better. So if you use the product and then you say, actually, I think that this one provision, we would feel more comfortable if it were drafted like this, we will take that into consideration. And we implement a lot of customer feedback. Also, like, for this, is there an e-signature integration? This is a question we've been asked before, and that's something now that we're working on. So I think, within the next few months, we should have something to kind of help with that. Okay, any other questions? Oh, do you offer nonprofit discounts? Oh, great question. Yeah, we can work with companies on things like that. If you go on to sixfifty.com/employment agreements and schedule a demo, we can work with you on a one-off basis. But yeah, we can work with nonprofits. Thank you for that. Okay, well, if there aren't any further questions, I'm just going to pause just for a few moments. Thank you for joining. We will send out a recording of this webinar after it's closed in the next few days. Again, if you want to learn more about this tool, you can schedule a demo at sixfifty.com/employment agreements. And I think we've put that into the chat. So thank you very much. Very busy time, we know, with the end of the year, and we're hoping we can really help. So thank you.